Friday is a big day for Sean Diddy Combs. The indicted rapper will present his arguments for bail in front of a new judge. But what does the prosecution have to say about this? We're going to preview both sides and what we can expect right now with Dina Doll. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, I want to do something interesting right now. I want to break down what we can expect from tomorrow's bail hearing in the Sean Combs case, what the arguments will be, who may actually win this. Will Sean Combs actually be granted bail, pre-trial release, after 2 months being locked up in the Metropolitan Detention Center? He was previously denied bail by other judges, but will the current judge overseeing this case, Judge Arun Subramanian, feel a bit different? This would obviously be a huge win for the former music mogul who's facing federal sex trafficking, racketeering, and prostitution charges. By the way, thank you for following us on our continued coverage of the Sean Combs case. And I want to call out our sponsor, Upside, because they help make shows like this happen. If you don't know what Upside is, it's awesome. It is a free app that helps you get cash back when you buy gas, groceries, food. This is real money, real cash back, money that appears in your Upside app that you can then transfer right into your bank account. Look here, I used Upside to find a gas station, claimed an offer, pay with my credit card, followed the steps on the app, I got cash back. So easy to use, and you can use it at all different kinds of places, restaurants, convenience stores. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen. But make sure to use our promo code SIDEBAR because you'll get an extra 25 cents back on every gallon on your first tank of gas. Hope you can check it out. So to help me break down what the arguments could be, what we can expect, and by the way, I'm basing this off of prior filings by both the prosecution and defense, but to help me break this down, I want to bring on attorney Dina Doll, who is joining us here in studio. Dina, good to see you. Thanks for coming here on set.
It's great to be here with you.
So a lot of things I want to get to. The first one I want to start with is actually something that happened the other day. So Judge Subramanian said this week, and I thought it was so noteworthy, that there was this hearing regarding whether the prosecution illegally obtained attorney-client privilege material from Sean Combs' jail cell. Put that issue to the side. At the end of that hearing, Judge Subramanian seemed to warn the prosecutors that they need to be prepared to distinguish Sean Combs' case from the case of Mike Jeffries, the former CEO of Abercrombie & Fitch, who was just arrested and indicted on sex trafficking charges in New York, the Eastern District of New York, another federal court. This was after Combs was already arrested. He is accused of operating an international sex trafficking ring where young men would be lured into sex acts using force, fraud, coercion, very similar to what Sean Combs is accused of doing. But in that case, Mike Jeffries granted bail, $10 million bail. That included home detention, GPS monitoring. We know that Sean Combs has offered a $50 million bail package, home confinement, 24/7 monitoring by private security. Visitor logs could be provided to the court, no phone or internet use. So you have these two cases, and the judge said to the prosecutor, be prepared to distinguish both of them. What do you think?
Well, that's certainly his best argument for getting out on bail because, as you said, their charges are very similar. Their wealth is similar. What they're able to do in order of providing the 24-hour security, all of these assurances that Diddy's lawyer is saying that they're going to do to the court, essentially that is how this other CEO got out on bail. The arguments we're going to hear from the prosecution is how they are different and essentially the same things that we heard with the initial bail hearing when it was denied. One, that he is a continuing threat to, despite even this 24-hour security. Diddy is known to very well be able to manipulate people. He'll be able to manipulate the 24-hour security. He can still be a threat in a way that he can't be behind bars. And how he was, where he was arrested, how he evidently had drugs on his possession, all of that is going to come back again. And then the idea of, is he going to interfere with the prosecution itself? Is he going to communicate to have more social media posts? Is he going to contact witnesses? So those are the differences that the prosecution is going to really stress, and the defense is going to stress the similarities between the two cases, in particular the charges and the wealth.
Let me ask you this. Generally speaking, for federal sex trafficking cases like this, my understanding, there is a presumption of detention, right? And it would be up to the defense to rebut that presumption. Prosecutors have said he hasn't done that. But generally speaking, it would be tough for him to make bail, let alone after being denied twice?
Well, to your point, for one, it's a different judge.
Yep.
And this judge gets to look at it de novo, as I said, a completely new review. He's not bound by the other judge's opinion on this. And every judge does look at facts a little bit differently. And then to your point, I think, where you started out at is the fact that this other CEO since that has gotten a very similar bail package. You do have to treat people similarly. You have to the prosecution now has to justify why he would get a separate treatment, which they didn't have to the first time around.
They might have had a win this week. I mean, we'll get into that in a second about what they're alleging. But one of the events that I think is going to come up, one of the events that prosecutors have highlighted before to suggest that Sean Combs is a danger, that he can't be out on bail, a serious factor in a bail analysis, by the way, how much you are a danger to society. And it's, again, something I think could be brought up, is the 2016 videotape of him purportedly beating his ex-girlfriend, Cassandra Ventura, in a hotel hallway. I believe she is referred to as victim 1 in the case. We don't know for sure, but it looks like she's victim 1. And while prosecutors have suggested that this is evidence of him attacking somebody who was trying to escape a freak-off in that hotel, the freak-off, the central allegation in the indictment, these coerced, sometimes drug-fueled sex parties, that this is evidence of sex trafficking, Combs' attorneys have said, look, this was an unfortunate domestic spat, okay? It's not evidence of racketeering or sex trafficking. It's just they had a really toxic relationship. And the defense has seemed to say, look, we have text messages between Sean Combs and victim 1 that show this was just a toxic relationship. The prosecutors have said, defense, you're cherry-picking messages. You're creating a misleading picture here. Rather, there are messages between the two that show, 1, it shows his physical abuse of her, and 2, his threats to expose recordings of freak-offs if she didn't do what he wanted. There are text messages that they highlight, you know what sick and disgusting S I was reminded of the other day? You forcing me to blank, or you were going to leak some S. I have a black eye and fat lip. You are sick for thinking it's okay to do what you've done. Dina, 2 different perspectives here. How important is that 2016 tape, and maybe just the relationship between him and victim 1 going to play into this?
Well, certainly for the first judge, that tape was important. It was brought up, during the hearing as evidence, as you say, to the danger of him to society. Certainly, we're seeing not only a request for bail in the defense motion, but a preview of their defense, which is that it was just a domestic violence incident, not, coercion as part of the sex trafficking ring. The violence in that tape is very graphic, very difficult to watch. It's hard to walk away, let's say, for them as a defense to minimize it, which they're trying to do is to minimize it. How this particular judge is going to view it, it's hard. I mean, it was a long time ago.
It was 8.5. That's their argument. They go, you're using a tape from 8.5 years ago to justify pretrial detention? That doesn't make sense. But at the same point, it's pretty graphic, and they say he's been violent ever since.
Right. And whether or not the second judge will view it the same way, I think that's very subjective. Right? Sometimes there's certain facts or evidence that come up, like DNA evidence, and you just know every judge is going to interpret that the same way, or every jury is basically going to interpret that the same way. But taking an 8.5-year-old tape between people who were, they were out and about in a relationship. There could, as we know, you can be in a relationship and also be, raped and assaulted, all that. But there is enough of a perspective. It's possible the second judge might see it completely differently.
Well, to be clear,
in terms of the bail.
They're not saying he did this, he beyond a reasonable doubt, he's guilty. They're just saying this is evidence to justify detention, right? How much do they have to prove it? Because one of the things the defense said is, this is before, by the way, we'll get into what the prosecution said he's been doing behind bars. But one of their earlier filings, they said they're making allegations he's reaching out to witnesses, that he's a danger, but they haven't proven anything. The defense said the prosecution cited a case about pretrial detention, but in that case, there was 3 days of hearings or multiple days of hearings. They heard witnesses talking about what happened. Does it have to be a mini trial in order to justify pretrial detention?
I mean, it really depends again on the judge, right?
Yeah.
And that's why I'm saying this is so subjective in some ways, because both parties, you have some great lawyers on both sides here making a completely different case about what that tape is about and trying to use it to, on the one hand, justify bail, on the other hand, say this is not enough to keep somebody who, because in our system, we are also innocent until proven guilty. You're going to be having somebody behind bars for a long time, So yes, although there is this presumption because with sex trafficking, he's a danger to society, you also kind of have to prove it. This judge might ask for a mini hearing, might say, hey, this tape is too old. I see where you're going, prosecution. This might be persuasive, but I need more. I need you to tell me about more that's happened more recently. That could very well happen.
So a large part of what I think is going to happen tomorrow, could be wrong, but I think a large part, is going to center around these allegations that Sean Combs has been improperly contacting witnesses and alleged victims in this case to, what the prosecutors say, obstruct the investigation. Now, the defense has said that the government is mischaracterizing all of this, that they haven't explained what about his conversations with these people was threatening or intimidating or obstructive. And they say even one witness actually contacted Sean Combs first, not the other way around. And when he found out that one of the witnesses was a grand jury witness, he allegedly stopped speaking to that person. Now, the prosecution says, tell you what, Combs is actually abusing his communication systems in the Metropolitan Detention Center right now, including using other inmates' phone privileges, a three-way phone call system, and he's doing it to reach out to victims and witnesses. And particularly, he's using his family to do his bidding. And the prosecution says, we have the recorded conversations to prove it. Now, Dina, here's the thing. Based on the ruling this week, there are certain aspects of what was found or photographed from his jail cell that will not be allowed to be used by prosecutors to say what Sean Combs has allegedly been doing in order to justify bail, because there could be a privilege issue. But they say they have these phone calls, right, that he's making. There's one call that's all redacted, and it was cited by the prosecution in one of their filings, but it seems like it was between him and his son, where he's instructing him on reaching out to people. If they bring those receipts, is that the end of the day?
If the judge, and the judge did seem kind of fairly on the defense side in terms of them going into the cell, getting the file that was marked legal and sorting through it. That's really serious to get into attorney-client privilege. He seemed kind of fairly upset about that.
Yeah, and they're going to decide that at a later date.
And they're going to decide that at a later date, but he knows what they did, the judge. I mean, so he might give more skepticism to what that phone call conversation was.
But the phone calls are recorded. They're allowed. They're supposed to be recorded. Prosecutors, isn't that free game? They can use it, whatever. I mean, and what he says on those tapes is what he says on those tapes.
Yeah, and maybe that will be enough. But if it's not spelled out as clearly as the prosecution is saying it's spelled out, but knowing what you know in the documents, you can kind of put it all together. That judge is not going to put it all together like the prosecution wants him to. I think he's going to be very careful about going into any of that documents that may actually have substantiated those phone calls. Because if it was just the phone calls, if the phone calls were that bad, why do the search? Why even try to get into a search?
Well, the search was a pre-planned wide search of the MDC. It wasn't, prosecutors will say, it wasn't targeted against Diddy.
I heard it was they said it was a pretext.
That's what defense says, but they searched other units. So who do you believe?
I thought that they admitted to that.
No, it was a pre-planned search, and prosecutors knew that part of that search was going to be looking at Diddy's cell or his unit. But they found homemade weapons, they found electronics, they found a lot of material. Defense says this was just a pretext to search Combs' cell, but it's who do you believe here? I think the bigger question is, are we even going to know what he said on those tapes? Because half that stuff is redacted in the prosecution's filing. Is there a chance we might not know what is exactly said or what he allegedly told people on those phone lines?
I mean, most likely it's redacted because they're trying to protect. If he was speaking about certain witnesses, grand jury witnesses are private, so they were, if he used names or enough information to know, then no, we're not going to know. Yeah. Unless this goes to trial and that witness ends up taking the stand and it kind of becomes a part of the evidence at trial. But if that's what's being redacted, it's...
You make a good point where the idea of how the defense can try to characterize what is said on that phone call and that it wasn't him trying to reach out. Maybe there's a more innocuous reason. And because I want to give you an example of something. Other than the fact that they said, he has a right to speak to people who in relation to his civil suits, or they contacted him. I want to give you an example of something. So this is whether it can work both ways. This was from a prior filing. It said, beginning on June 26, 2024, only after witness 1 had been served with a grand jury subpoena and had counsel, the defendant initiated contact with witness 1, which the defendant attempted to obscure by initially calling witness 1's wife and later communicating with witness 1 over a VoIP service, including by text and a call lasting over 7 minutes. The following day, phone records indicate that witness 1 spoke with counsel for the defendant. Following witness 1's testimony in the grand jury on July 25th, 2024, so again, this is all before Sean Combs was arrested, the defendant called and texted witness 1 again. The defendant's repeated contact with witness 1, despite his apparent knowledge that witness 1 was represented by counsel and had received a grand jury subpoena, undermines defense counsel's previous denials of the defendant's interference in the government's grand jury investigation and shows that counsel cannot stop the defendant from contacting grand jury witnesses. This concern is amplified by evidence indicating that the defendant appears to have deleted his messages with witness 1. So, two different perspectives here, right? Prosecution says, Judge, you can't let this guy out. He's going to contact people in the case. He's going to interfere with the investigation. He deleted the messages of it. The other way of looking at it is, if his defense counsel spoke with witness 1, is it not as bad as the prosecution's making it seem?
Anyway, this is going to be the most interesting part about tomorrow, for sure. Because on the one hand, him reaching out to witnesses, like, game over, right? I mean, if the prosecution can, as put forward to the judge, really back it up with just those phone calls that it was clear he was trying to, contact these witnesses, trying to get them to change their story or whatever, then it's over. Because at the end of the day, the judge is going to really want to protect the integrity of this prosecution. And if he cannot be controlled behind bars, he's certainly not going to be able to be controlled in his multi-million-dollar homes with private security and family members coming. That's just game over. I mean, the defense's argument is essentially that they have to put on a defense, and so they have to talk to defense witnesses, which is valid. But then really the defense should have contacted these defense witnesses or the lawyer for the defense witness, as you said. The fact that it was initiated by him, by Diddy, I don't see how you really explain that around. I mean, It's possible the defense has something up their sleeve tomorrow, but there's no justification at all for having him contact the witnesses.
And look, you made a good point and this was raised as well. Prosecutors are like, can't trust him with the 24/7 private security team. If he's able to manipulate inmates and other people, he can manipulate the security team to do his bidding too. I do want to read you something else. So this is from the prosecution's filing. They don't just say that he was working on communicating with these people. Dina, I want to actually ask you about something else. So they also allege, prosecutors, that while he's been behind jail, he has been using his family to push through a social media campaign to influence a potential jury. And they said that one way he was doing that was posting about his birthday, his family calling him on his birthday while he's locked up. You hear him on the other line, and that he was actually studying the analytics of this from behind bars. And they say they have communications to say that he did this to taint a future jury pool or influence a jury pool. What do you make of that? Some would say there's no jury yet, but if he's saying this is my goal, what do you make of that?
Well, this is a little bit different.
It is.
The law is very clear about interfering with witnesses. But honestly, somebody with his fame are always trying to taint the jury pool. Let's be frank. Even his lawyer with his statements has been trying to taint the jury pool. I mean, that's kind of almost not fair game, but it happens. It happens all the time. Lawyers give interviews about their cases in advance. And if a lawyer allows a client to, most of them don't. But, we saw Alec Baldwin try to do it, right? That backfired. But this is something that is much harder to say, even the social media posts, even him, there's no restrictions on social media posts. Nobody's gagged him.
His family was actually posting on
it. But I mean, if he was behind the scenes, the puppet person, it's not like he has a gag order on him or any of the people have gag orders on him. If that were the case, okay, we're talking about something different. But we're in this really gray area because
there is a gag order about releasing grand jury material and other non-public information. But I guess his argument would be it's just about his birthday. He's allowed to change the public narrative because he's a public person.
Yeah, I mean, let's say you weren't famous. You could go and talk to your friends about it. You know, there's no limit on, you know, and here that message wasn't even actually talking about the case. They thought it would help him, but it could backfire just as much. People could say like, oh, you're trotting out your kids to try to make you seem innocent when here you've done these horrible things to children. Like, that's disgusting that you're using your kids that way. So that social media post could have helped him. It also could have hurt him. So it's a little bit different. It's almost like more of a PR campaign, which, you know, is not something that he's restricted to not do. So
I wanted to ask you about this too. So I thought this was a really interesting argument. So the prosecution has said, you know what? It's unfair for Sean Combs to be allowed bail in this way. Why? It shows a two-tier justice system. Combs, he can be permitted to stay free on sex trafficking and racketeering charges because he has the financial resources to turn his home into a private prison, 24/7 monitoring, giving up all of his privileges, $50 million bond, where you have a defendant of lesser means who couldn't put forward this attractive bail package. That person's denied bail. That's not fair. And that person would be locked up while waiting trial. Sean Combs' defense team has said, we're offering this package and these conditions because he is wealthy. The government said he is a flight risk. He's a danger because he has the money and resources. So you know what? This bail package looks like this. The reason it's so expensive, the reason he's essentially turning his home into a prison is because this would be the only way to ensure all of the concerns the government has. Who's right?
Well, that's up to the judge, but really they both have a valid point. I mean, on the one hand, when you see the list of what they're willing to pay for, it does shout out like just wealth, like not only the private security all the time, but the monitoring, the drug testing. I mean, you, a regular person, there's no way could do anything close to this. But then on the other hand, that's partly why he's behind, jail, because he has access to a plane, a private plane, and he has all that money. And so that is taken into consideration when deciding if somebody should be behind bars as their flight risk. So I think that they both have a valid point, and I don't think the judge is going to decide it based on that, whether or not his wealth and how he's using it is fair or not fair. I think they have addressed, the defense has addressed the fleeing concern because of his wealth with his 24-hour security. We've seen with that CEO, he had wealth and he did 24-hour security and the court didn't really mind there. I don't think there's going to be a fairness aspect. It's really going to be, is he going to interfere with the prosecution with witnesses, and is he a danger?
So the danger element we've talked about a lot. The risk of flight, let's amplify that a little bit. So this is another really important factor when we talk about bail. The prosecution says he's facing 15 years to life in prison if he's convicted. He has an incentive to flee. He has the resources, the money to do it. Defense says, you know what? He could have fled the country before he was indicted, but he didn't. His attorneys cooperated with prosecutors. He surrendered his passports. Family members surrendered their passports. He came to New York to surrender himself to authorities before he was arrested. He even tried to sell his plane. And they have said in a recent filing that he's not going to flee. He's not going to abandon his family, his livelihood. When you weigh those two, what do you think?
I mean, I think that the defense addressed it well enough in their filing that he's not a flight risk. In terms of the security, the fact that he turned over his passport to his lawyer in advance, the fact that he didn't flee is a good sign, obviously, and all of the roots that they talked about with his family, and that he does have, young children, and some of them, he is the sole parent. Because the fact is every defendant technically is a flight risk, regardless of somebody's wealth or not. Putting somebody out on bail, there's always the risk they can flee. That's why they put up the money bond. But still, somebody can go. So you're never going to 100% take away that risk. I think that they have done enough to show that people do sometimes do kind of shady things that make you think they're going to be a flight risk, right? Like when Scott Peterson was found near the San Diego border, before his trial, he didn't do any of that stuff, which helps him. Plus the monitoring. So I think that they have addressed that risk enough for him to be able to get out.
I agree. Although I think he has a weaker argument when it comes to the final point I wanted to address. He has suggested, or his attorney suggested, he can't be at the MDC anymore because he can't properly prepare for trial. You know, he can't review all the mountains of evidence there. He's like every other criminal defendant, though. Should he be allowed out so that he can properly prepare for his case because it's more expansive, it's more complicated? Feels like a weaker argument to me.
Yeah, I agree with you. When I read that part, I also thought, this is a stretch, because you could use that argument, for every defendant then. It is true, they talked about how there's like a huge number of evidence that he has to go through, and that's true. But, it's just that the defendant has a right to be able to like assist in their case. I think that interpretation of assistance doesn't necessarily mean he has to go through literally every piece of evidence himself. But even if he does, this trial is going to be a long time. He might still be able to go through all the evidence. But no, I think that is definitely the weaker argument. I don't think we ever really decide bail based on the amount of evidence you have against a defendant. Because it could work against them the other way, too.
True.
You could say, hey, this case doesn't have much evidence. Let's keep him in bail. So,
and the prosecution has said he gets a conference room. He can speak to his attorneys. He gets what he needs. I don't know. I think it's going to be addressed. We'll see. So I think we've hit everything, maybe not everything, but the big points that I think might be addressed tomorrow. We shall see what happens. Dina Doll, thanks so much for coming on. Appreciate it.
thanks for having me.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.